in the appeal of Carriacou Devcor Ltd against Margaret Corion and another.
Just take a moment to adjust this.
Yes, of course, my lord.
Mr. McGee, some preliminary matters, if I may.
Yes, of course, my lord.
The first is that we understand that the Attorney General has applied to withdraw his appeal.
That's right. Her appeal, yes.
So you appear, therefore, on behalf of Carriacou Devcor Ltd.
That's right.
Yes. Thank you very much. The second relates to the rule in Devian Roy, concurrent findings of fact in the courts below.
Yes.
It seems to us, on a very preliminary view of the matter, that there are two main points in this case. One is the question whether, when the 1914 conveyance expressly stated that all of the Great Ants estate was being conveyed, that included the disputed territory.
Yes.
And the second relates to the issue of the foreshore.
Yes.
Now, as far as the first is concerned, both the judge and the court below found that the disputed land was included within the Great Ants estate.
Yes.
So far as the second issue is concerned, both the judge and the Court of Appeal below concluded that there was insufficient evidence to raise the issue of the foreshore.
Yes.
Now, we would like to hear you, please, in the space of 30 minutes, on why the principle in Devian Roy, Das and Marchand should not apply, bearing in mind, of course, it's the usual practice of this court not to go behind concurrent findings of fact below, save in exceptional circumstances.
Lord, yes, and of course I'll address that at the outset of my submissions, if convenient, or during the course of them, as your lordship wishes.
Well, we'd prefer to hear you on those points distinctly.
Yes.
Please, and we allow you 30 minutes in which to address us on that.
Lord, yes. May I turn straight to that point then?
Thank you very much.
So, in relation to the 1914 conveyance, my Lord, my submission is that the courts below approached the question through fundamental errors of law as to the nature of what was relevant and admissible evidence. In a nutshell, in relation to the 1914 conveyance, the approach taken by both the trial judge and the Court of Appeal was that the matter was resolved by the expert evidence of the surveyors on each site. We say that approach was simply wrong. Neither of them were alive in 1914. Mr. Allain, who was the respondent surveyor, hadn't even visited the property. It was then said by the trial judge, at least, that Mr. Thomas, the appellant's expert surveyor, had conceded the point. He hadn't, but even if he had, it would have simply been irrelevant. So,
forgive me, it wasn't solely by reference to the evidence of the experts, was it? There was evidence as to the topographical features of the site.
So far as the judge was concerned, looking simply at the judgment at first instance, she relied, we say, on the expert evidence. She also relied on the 1904 plan, but on the 1904 plan as interpreted by the experts. We say it simply didn't show that. It is right that the Court of Appeal also referred to Miss Corion's evidence and Mr. Lendor's evidence, but they weren't matters relied on by the judge, and they took the matter no further. The question, the proper question for the court, was one of the construction of the 1914 conveyance, and in particular, what Grand Ants estate meant in 1914. And there was no evidence on that question whatsoever. All that was relied on by the respondents in that connection was the 1885 conveyance of the Grand Anse estate of a much larger acreage, and a 1904 plan, not of the Grand Anse estate, but of the Harvey Vale estate. So we say this is not a question of a detailed review of findings of fact of the judge of first instance. It's a completely wrong approach to that evidence. Putting it bluntly, the evidence of the expert surveyors added nothing to the judge's reading of the 1885 conveyance, the 1904 plan, and the 1914 conveyance.
You called expert evidence on this issue, did you?
We did.
Yeah.
It did. Both parties called expert evidence on that issue. We were clear, though, and are clear, that it's a question of construction. I think that's common ground with my learned friend, but he'll speak for himself in due course. But we say that to treat the matter as one that could be resolved by the expert evidence, or even by a concession, which was not made by our expert, is simply wrong. And any other evidence that there was, mentioned in passing by the Court of Appeal, but not relied on rightly by the judge at first instance, simply took the matter no further. So far as plans in 1980, 2003, and 2013 are concerned, we say they simply can't have any conceivable relevance to what Grand Anse estate meant in 1914. So, my lords, my lady, in a nutshell...
But you do accept that the 1904 plan is relevant evidence that the judge was entitled to take into account?
Well, we say, my lady, that the 1904 plan took the matter no further for two reasons. First, because there's no reason to think that the vendor, that the transferor or transferee under the 1914 conveyance had ever seen the 1904 plan. My learned friend has a point about it being a public document and being kept in the court and being lodged in the court, but we say there's nothing in that point whatsoever. There's no reason that they would have had regard to it, for the very simple reason that it was a plan of the Grand Anse, of the Harvey Vale estate, not of the Grand Anse estate. That's the first point, lady. And the second point is this, that if one were to examine the 1904 plan, it doesn't tell one anything about whether the disputed land was part of the Grand Anse estate or not. So, except it was a document 10 years earlier, but it bears, it simply doesn't bear on the question. The third of my 2 points is this, that we know that the area of the Grand Anse estate changed fundamentally from 1885 to 1914. In 1885, according to that conveyance, it was 160 acres. In 1914, it was 106.5 acres, or thereabouts, or more or less in each case. But it was fundamentally a different size of estate. And so we don't know when that change occurs, but there's no reason to think that it occurred before 1904. That's as likely to have been before 1904 than it was after 1904. So that's, if you like, the third of my two reasons as to why the 1904 plan doesn't take one any further at all.
Why would that mean that the Crown owns it?
Well, the Crown owns it for two reasons. If the 1914 conveyance was ineffective as a purported transfer of land which included the disputed land, then the Crown owns it because it was in possession of it through Carriacou Devcor Ltd, CDC. That's one reason. The other reason...
Sorry, can you just repeat that?
Sorry. If the 1914 conveyance was ineffective as a purported transfer of land which included the disputed land, then the court ought to have found that it was land which belonged to the Crown because the Crown was in possession of it through CDC.
To whoever was the purchaser in the 1885. If you're relying on the disparity between the 160 acres of land conveyed in 1885, 106.5 acres in 1914, so something has happened, you say, between those dates, so that 53.5 acres. But why did you say that what's happened to it is that it's reverted to the Crown?
Well, lady, we don't accept the premise of that. We don't accept the premise that in 1885 it was conveyed at all. So my learned friend says in his written case that it is common ground that the disputed land was part of the Grand Aunt's estate in 1885. We don't accept that. There is no plan attached to the 1885 conveyance at all. Neither, for what it matters, is there a devolution of title shown from the transferee under the 1885 conveyance to the vendor under the 1914 conveyance. So it's relied on, I think, by my learned friend to say, well, look, the Grand Aunt's estate was transferred from A to B in 1885. But it's got the same problem as the 1914 conveyance. There's no plan attached to it, and there was no evidence before the court as to what the Grand Aunt's estate consisted of in 1885. So we don't accept that there was a conveyance by anyone in 1885. But moreover, the starting point, because in the common law world, English law, but also in Grenada, we have a concept of relative title. And the answer to that, and it's very well established, is that the person in possession has title to that land unless someone else comes along and proves a better right to possession. In other words, proves a conveyance or adverse possession for the requisite period. In any event, as my learned friend, I think, has fairly accepted in his case, he was coming to court asking for a declaration that the Corions, the estate, was the owner. The burden of proof, therefore, rested on them to show that, to prove that point. They didn't do so. But that's not the only reason why, if they don't establish the case, then property is in the Crown. It's not just about that point. The person coming to court has to prove it. It's one, as a matter of common law, the person in possession, and we say that was the Crown through CDC, and I know my learned friend doesn't accept that, but we say that there's very clear evidence as to that, and it was never disputed at any point. It was clear. CDC,
what was never disputed at any point?
It was never disputed at any point that CDC took possession by license from the Crown because they went on there, put in bulldozers, my learned friend says, constructed a marina. They were in possession of the property.
Was there any evidence that the Crown was in possession of the land before the grant to CDC?
No. There was no evidence either way on that question. But that doesn't matter. If someone enters upon land and is in possession of that land, and another person comes along and says, "You're a trespasser, this land is mine," then in order for them to succeed, they need to show conveyance to them or adverse possession for the requisite period. Now,
If they have a conveyance but it doesn't have a plan, then too bad. They've forfeited the land to whatever trespasser chooses to come onto the land.
well, the conveyance has to be a conveyance of the land in question, and that needs to be proved. And they brought along a couple of conveyances, but there were no relevance, we say, to the question of the disputed land, because they were not conveyances of the disputed land. They were not proved to be so. There was no evidence that they were.
Well, that's circular, isn't it? I mean, there was evidence called as to what was comprised within the great aunt's estate at 1885 and 1914.
Well, Lord, with respect, we say there wasn't that evidence. There was, I mean, to make a slightly obvious point, there was no one alive at the date of the trial who was alive in 1885, obviously. And all that the estate sought to do was to say, we have got the 1885 conveyance, we have got the 1914 conveyance, we've got the 1904 plan, and then they relied on a plan in 1980 as well, which we'll look at if we need to, although hard to see it can be of any conceivable relevance. They didn't adduce any evidence as to what people considered the Grand Aunt's estate to be. They didn't produce any plans from around that time, anything in the history books, or anything like that at all, or anything to do with the topography, to show that that was the Grand Aunt's estate. What one might have expected them to do was to produce something in the nature of the history of the Grand Aunt's estate. What was it? How did it become known as the Grand Aunt's estate? When was it first got together? Who owned it? Was it a plantation? Etc. And there was absolutely no evidence of that whatsoever. Instead, they simply got their surveyor to go along and say, I say, in my expert opinion, that this was part of the Grand Aunt's estate. But on analysis, all he's relying on is a 1904 plan of the Harvey Vale estate. So we say that the court at first instance and the Court of Appeal were wrong in law in the way they approached the question of construction. And if, as they should have done, they concluded that there was no evidence that the 1914 conveyance was a conveyance of the disputed land, then it followed that they did not succeed in getting their declaration, and that the Crown, being in possession, succeeded, subject to one point. And the one point is this, that the estate also argued in the alternative that they had title by adverse possession. It's only pleaded in a sentence or so in the amended pleading, and if I'm right, they would have to show, I think, either 30 or 60 years in order to establish that. The evidence was heard on that issue, but neither the judge at first instance nor the Court of Appeal felt it necessary to decide the point. So if your Lordship are with me on this, the right order to make would be that the matter be remitted to the judge at first instance to make findings on the question of adverse possession. But it's right that that point, if successful, we say it won't, but this is not a matter for this court. We say that, but if Malone and Friend were successful on that point, then that would establish title.
Sorry, that would establish...
That would establish title in the name of the estate. So if they could show the requisite period of adverse possession prior to CDC taking possession and building the marina, then they would succeed, notwithstanding they couldn't show a conveyance, and even if the seabed and foreshore presumption applied,
All right.
because that can be defeated by adverse possession as well.
Now, can you help us in relation to the foreshore point?
Yes, Lord, of course. So, we say that that was engaged, and the starting point for my submission is that it was common ground, learned friend disputes it, but it was common ground, and is so recorded in the Court of Appeal judgment that the land was covered by seawater.
When you say it's so recorded, do you mean recorded as common ground?
So I'm sorry, I've been slightly inaccurate. Not recorded as common ground, but the Court of Appeal say, let me just, I don't want to misrepresent the position at all. They were clear so I wonder whether it might just be worth turning this up. It's page 189 in the Court of Appeal's judgment. So, Your Lordships, Ladyship, see paragraph 8 and paragraph 9. It's paragraph 9, just after the quotation from Halsbury's laws. The appellants support this presumption by reference to the evidence that the disputed land is swampland that is almost entirely covered by seawater. Therefore, it's part of the foreshore, belongs to the Crown, etc. And then the next paragraph over the page. If the fact that the disputed land is swampland covered by seawater is sufficient to invoke the presumption of Crown ownership, the appellants will be on good ground because the evidence of water coverage is not disputed by the respondents. However, the judge rejected this submission. She found that although the disputed land may be referred to as swampland, this does not make it Crown lands. We say that there were a number of errors of law made by both the judge of first instance and the Court of Appeal. The first is this, that both the judge at first instance and the Court of Appeal accepted the estate submission that the seabed and foreshore presumption was displaced in Grenadian law by the Crown Lands Act. This is a point we see referred to, if your Lordships of the Court of Appeal are looking at the Court of Appeal judgment, going on to page 193. It's Roman 3 at the bottom of the page.
Sorry, page?
Page 193, my Lord.
Yes, thank you.
Roman 3 at the bottom of the page. Yeah. It's the judge, Learned Junior reminds me, the judge dealt with it as well, the very same point. But I wasn't going to go to it in the interest of time. So one of the reasons it was rejected was because of the Crown Lands Act. And the reasoning was this, that the Crown Lands Act listed certain properties that are Crown's lands. For any other properties, this was the submission, the Crown had to prove title in the ordinary way. In other words, it could not rely on the presumption it was set. That is wrong. We set out in detail why in our case. I'm quite happy to go into it in as much detail as Lordships want, but it's not a point to which Learned Friend responds in his respondent's case. And so we're maybe right in hoping that there's common ground on that point. Perhaps I can go to my...
I think, Mr. McGee, that the point which is made against you is a more fundamental one, and that is whether there was sufficient evidence to raise the issue of foreshore at all.
Yes, that is one of... There's a number of points that are raised, but there is that, I accept, my Lord, fundamental point that it wasn't raised. We say on that the evidence on the point was quite clear. It's not us seeking to overturn concurrent findings of fact. there was that finding, and I've taken Your Lordships to the passage in the Court of Appeal judgment that make that clear.
But it's not a finding that it was seawater, it's a finding is that it was covered with water at some point, sometimes. I don't think there's no dispute that it's swampy land. Does the finding of fact go any further than that?
If one looks back to page 189, it's 5 lines from the bottom of 189.
Sorry,
189.
Yes.
So this is the Court of Appeal judgment, the passage we were looking at a moment ago.
Well, yes, what about in the findings of fact will be made by the trial judge? Where is it in the first instance judgment?
The trial judge doesn't make reference to that specifically.
So no finding.
Well, there's no specific reference to it. Until seeing Malone and Friends' case, we didn't understand it to be a matter of debate that the water was seawater at all.
Sorry, so there's no finding at first instance that the swampy land was covered in seawater?
Lord, that's right. There's
So
no...
how can the Court of Appeal make a finding that it was covered in seawater?
Well, there was no... It was clear that it was largely covered in water.
Yes.
There was no debate that that water was seawater.
Well, why should there be?
Well, because the point is...
I mean, the point is, this foreshore point was only raised, as I understand it, in your client's closing written submission. So why should there be any debate about the quality of the water in the swamp?
Your Lordship is right that the point was raised for the first time in my client's closing submissions after hearing the evidence and obviously before judgment of the trial. It was a point that was raised by both sides in their written and oral submissions to the Court of Appeal.
Yeah, but the point is, you're saying that it was common ground that the water in the swamp was seawater.
Yeah.
But there's no finding of that. So I just don't understand the basis on which you're making this assertion.
Well, Lord, there was evidence at first instance, and I can take your Lordship to it, that it was indeed covered by seawater.
All right, but was that expert evidence?
No.
So we don't know if it was salty water. Was it brackish? Or was it pure seawater? Was it brackish water? What was it?
Well, the evidence was that it was seawater.
Well, we say the evidence, but what evidence is that?
If your Lordship would go to page 288.
288.
288. This is the cross-examination of Miss Corion at trial.
Bear with us a moment, please. Yes.
Yeah, sorry. So it's line 15. Yes, now I want to ask you, Miss Corion, is there any part of the disputed property that the seawater comes into? And the answer is into the carronage where the boat docked. There's a circle there. There's a circle of disputed property. The way the land is situated, it's an area for docking boats. And asking simple questions, all right, is there, answer well, over the page, any part of the disputed property the seawater comes into? Yes. But there are other references.
Well, that's not evidence that the swamp was covered in seawater.
Yeah.
That's evidence that part of the disputed property was covered by seawater.
But what,
No, it doesn't
was it
say.
tide, or
Yeah.
when there's a storm, or when was it covered by storm?
Well, there's further evidence about the extent that that was so.
But the carriage where the boat docked isn't the same as the swamp, is it?
No, it's not.
And we're talking about an area which I thought it was common ground was a swamp.
Well, it's got a number of different things in it. Partly it's covered by mangrove swamp, but not all of it. And Miss Corion is very clear that part of the disputed property, I'm looking at page 288, is an area of seawater where a boat is docked.
Well, she doesn't say that. The question was, is there any part of the disputed property that the seawater comes into? Yes.
And she says, yes, there is, where the boat's docked.
What I was reading over the page
Yeah.
is where the answer comes. But the question is there an area where the seawater comes into?
Yes.
So there's an area where seawater comes into, but what is the composition of the water in that, even in that area? No evidence that it's pure seawater.
But all we have is that it is
That's the
that
point, isn't
from
it?
her.
This was, when these questions were being asked and the answers given, this wasn't an issue.
Well, it's right, my lord, that the foreshore and seabed presumption had not been raised at that.
So it's not an issue that's being, I mean, this is just making something out of an exchange at this point, directed presumably to a quite different issue.
Well, all I can do is take your lordships to the evidence that there was
I'm grateful for that.
on
I'm
the
grateful
issue.
for that. And it was not of sufficient importance for the judge to make any finding.
Yes, and there's other evidence I'll take your lordships to in just a moment. But and your lordship is absolutely right that the point was not raised until it was raised in the closing written submissions of CPC. No objection was taken to it being raised. And it was dealt with by both parties in their written submissions and oral submissions to the Court of Appeal. Again, without objection to the point being raised. So the point that my learned friend makes on that is we submit pretty late in the day. Can I take...
But the evidence you've thus far shown us suggests that the Court of Appeal's summary in paragraphs 9 and 10 on page 190 and 191, I mean, is by no means a summary of the evidence. When they say almost entirely covered by seawater, whereas all the witness was prepared to say is that some part was, and it was a careenage where the boat docked.
Well, your lordship's absolutely right that it's not a summary. If there were only Miss Corion's evidence in the passage that I showed you, that would not be a fair summary of that evidence. I entirely take that. But there was more evidence. I'm going to take your lordship to 2 or 3 other passages.
Was the building that Devcor undertook, was that limited to the swampy area?
What they did, as I understand it, was to reclaim that land.
But they've only claimed possession of what you would say was foreshore, not any of the driving.
No, we say the whole of it was seabed or foreshore.
The whole of what?
The whole of the disputed land. There was further land to the south of that, which is not part of the disputed land. I don't know if we would...
I thought the disputed land went quite far inshore, beyond the swamp.
Lady, no. I wonder whether it might be helpful. There's a number of plans. At some point, if I may, I'd like to take your ladyship through the various plans and conveyances as swiftly as I possibly can, because otherwise it can be confusing. But for the moment, can I just go to the sketch plan we've got in our written case at 728?
Yes.
It might be convenient, can I suggest, to have that sketch plan up in the hard copy key documents bundle, because then in due course we can compare it with the plans in the electronic bundle.
Yes, it's helpful. Thank you.
Yes. So if one looks there, it's not perhaps the best sketch in the world.
But forgive me, Mr. McGee, we mustn't lose sight of the fact that the point that's being addressed now is whether there was sufficient evidence to raise the issue of the foreshore.
Yes.
And the fact that there may be seawater or brackage water over the whole or part of it would not necessarily support the view that it was below mean high water mark.
Well, we put the point in two ways. Firstly, it's clear that the Court of Appeal were right to say that it was almost entirely covered by seawater. If it was almost entirely covered by seawater, then it was on the seaward side of the mean high-level watermark, wherever that was. And one doesn't need to determine that. Even if that wasn't so for the whole of the land, it was so for at least part of the land. And there's good evidence, I'll take your lordships to it, to support what the Court of Appeal said at page 189. If that's so, then the foreshore and seabed presumption is engaged. But we put the matter in a different alternative way as well, which is this. Even if it might not be the case that the foreshore and seabed presumption were engaged, the burden was not on CDC to show that this was seabed or foreshore. The burden rather was on the estate to show that it was not seabed or foreshore. Why? Because on any view, the disputed land bordered the sea. On the western side of it, there is open sea. And on any view, there was a lot of evidence of water there, of fishing there, of oysters, crabs, etc. And therefore we say that the burden was on the estate to show that the presumption didn't apply. It needed to do that because if the foreshore and seabed presumption had applied, then the estate did not get home by showing a purported conveyance of the disputed land in 1914. They would have to go further and show a conveyance by the Crown, because that's the power.
But that's when the presumption is engaged.
Yes.
The question is whether the presumption is engaged.
Yes.
And you're saying that the legal burden lies on the person who claims ownership to show that it was not foreshore.
Yes.
So if they can't do that, you don't even get to the foreshore presumption because they haven't shown that it's not foreshore. Is that right?
I do say that. And I say that.
So but this arises only because it bordered the water and there was water over it and there were oysters and so on. So this sounds like an evidential burden rather than anything more than that, doesn't it? I mean, supposing I own a golf course, golf links that borders the sea. Do I have to prove it's not foreshore?
Well, Lord, I entirely accept that it's an evidential burden, not a legal burden, but it's a burden, nevertheless, which was not discharged.
I see.
And obviously, it's not going to apply in any case, and it's fact-sensitive, but on the facts here, upon which there is no dispute, on the one, there is...
So this is why you have to dispute that the 1885 conveyance doesn't even cover the disputed land. Because if the disputed land was included in the 1885 conveyance, then that shows that the Crown must at some point have alienated the foreshore to the seller of that land or its predecessor in title.
No, lady, it doesn't depend on the 1885 conveyance. Because even if, let's assume the 1885 conveyance had a plan to it which showed quite clearly that it included the disputed land, and assume that Malone friend could show the devolution of title from the transferee under the 1885 conveyance to the transferor under the 1914 conveyance, and that there was also a nifty little plan attached to the 1914 conveyance showing that that included the disputed land. It would not get him home. The reason it wouldn't get him home is that if the seabed and foreshore presumption is engaged, it is only rebutted in one of two ways. First, by showing a conveyance by the Crown, or alternatively by showing adverse possession. And the 1885 conveyance was not a conveyance by the Crown. So that wouldn't have advanced matters in my submission. That's the important, that's, I think, as I said, the power of the presumption. It's not rebutted simply by showing a conveyance. It has to be a conveyance by the Crown. And that's why we say here that given that on the agreed facts there was clearly a question as to whether this was seabed and foreshore, and if it was seabed and foreshore, then even if the 1914 conveyance was to be construed as transferring the disputed land, it would not be effective to do so. Then it was incumbent on the estate to adduce evidence that the seabed and foreshore, that it was not seabed and foreshore.
But the immediate question is whether the presumption is engaged.
Yes.
And so far as that immediate question is concerned, were the judge and the Court of Appeal entitled to come to the conclusion that they did?
Lord, they were, and I wanted to circle back to that point. I've taken your lordship's...
Because we've run over the period allowed for your submissions in relation to that point.
Yeah.
So if we can now draw that to a conclusion.
Yeah, well, Lord, on that point, I simply say that there was other evidence, and if I can perhaps crave indulgence just to give your lordships one other reference, which is this, page 351. This is Mr. Thomas's evidence in cross-examination. And it's starting at line 9 of his cross-examination. How much of the disputed land is covered by water based on your knowledge of the area? By water, 90% up to 100.
Well, that's very definitely not seawater.
Well, the question, Lordship is absolutely right to make that observation, of course, that the point is not being, he doesn't directly address the question of whether it's seawater or not. But there was also lots of other evidence that this was an area where there were oysters, crabs, fishing. It was part of the marine ecosystem. Perhaps I can give your lordships, that rather than taking your lordship to it all, give your lordship some more references. Mr. Lendor's cross-examination, page 308. Mr. Alain's witness statement, page 500. That's about water. In relation to oysters, crabs, fishing and ecosystem, Ms. Corion at 466 and 504. In relation to the ecosystem, this is from a marine biologist, Mr. Jules at page 470 and Mr. Lendor at page 511. So we say there was ample evidence for that conclusion. The courts were wrong to say the presumption was displaced by the Crown Lands Act. The Court of Appeal was wrong to say that in order to establish the presumption, one needed to adduce evidence of where the high water mark was. I think my learned friend accepts in principle my submission on that. In that he accepts it's not necessary to do so in every case. The Court of Appeal appeared to consider otherwise. And they were also wrong, both the judge at first instance and the Court of Appeal, in failing to recognise the point I've just made, that the burden shifted to the estate to show that the presumption didn't apply. So we say there were all these errors of law in relation to the seabed and foreshore presumption.
Sorry, the last again.
The last point, Lord, was this, that the judge at first instance and the Court of Appeal were wrong in failing to recognise that the burden in fact rested on the estate to show that the presumption did not apply.
Even in a case where the evidence closed before anyone on the Crown's side suggests that it did apply.
Well, Lord, that point goes, in my submission, to the question of were we entitled to take the foreshore and the seabed presumption, given that it was not addressed prior to written closing submissions.
So no evidence was deployed in relation to it?
Well, there was evidence...
Yes, but the evidence wasn't deployed in relation to it.
Look, I accept the point. But the question is simply, were we allowed to take that point or not at all? That's a procedural question. There was no objection made. The judge decided that the foreshore and seabed presumption did not apply. She addressed the question, and the Court of Appeal addressed the question as well. It was not said when we put in our written submissions, you cannot take this point. It might be fairly said something about the strength of the evidence, but we say that given that the court at first instance did not say that procedurally we were barred from taking the point, and the point was addressed by the judge at first instance and was addressed by the Court of Appeal, then it's a point that's properly in play and therefore enables me to make submissions as to the application of the presumption.
So there's a presumption that the presumption applies. And what is the presumption? The presumption is that if the land is covered by seawater, then it's owned by the Crown, and unless you can show a conveyance by the Crown to somebody else, however many years ago, you cannot rebut that presumption.
Or adverse possession. Lady, yes. There's one...
Well, adverse possession is, given that we're talking about foreshore, which is covered, I think, by water,
yes.
What does it mean to adversely possess it?
Well, the answer is it would not be easy to show adverse possession. I can imagine, I suppose, if one had a commercial fishery, that the sea pens, one might be able to show adverse possession of that area of the seabed. So that might be one example. Or if one built a pier out into the sea and had a marina there and had boats there, and one might be able to show sufficient exclusive possession of that. But your Ladyship's absolutely right that it will be difficult in practice for anyone to show adverse possession, certainly of an area that's covered all the time by the sea, and even of an area that's covered at mean high level watermark.
When you raised this point, did you ever suggest the evidential burden was on the claimant?
We did suggest that.
Where?
It was a point put clearly by the Attorney General in oral submissions in the Court of Appeal, Lord, page 458.
What about before the judge?
For the judge, there were just the written submissions.
Well, that didn't raise that point.
That didn't raise that point. In written submissions, the question of burden of proof in relation to there are 2 points. As my Ladyship says, there's the presumption about the presumption. So far as the foreshore presumption is concerned, They were raised squarely in written submissions by CDC before the first instance judgment. And learned friend accepts that. And they were also raised by all parties in written submissions to the Court of Appeal. As far as the point that I've been making for the last couple of minutes, that given the circumstances of this being land next to that abuts the sea on the western side, which on any view has got incursions of water into it and fishing and crabbing, etc., that creates an evidential burden on the estate. That was a point that was put clearly in argument to the Court of Appeal by the Attorney General. I'm not sure one needs to go to it, but we'll go to it. Very happy to go to it if you'd like me to. It's page 458 to 9 of the transcript of the hearing in the Court of Appeal. But, lady, if I can return to the fundamental point about the scope and function of this.
My concern is that, for all we know, all the land in Carriacou and other small islands is held by people on the basis of conveyances which don't have plans. And that now the Crown is going to say, well, we can build on all that shoreline. You may have thought all these years that you've owned it, but you've not done anything to assert your ownership of it, unless you can show that in the middle of the 19th century or earlier, unless you can produce a conveyance from the Crown to someone and prove that the conveyance to you, a whole chain of title, and that this is the same land, we're going to build on it and not pay you any compensation. Now, isn't that risking causing a lot of problems in island communities like this?
Well, lady, can I try and answer that in two ways? Firstly, the land immediately to the south of the disputed land is the main part of the marina. I don't know whether you've got the sketch plan open at page 728.
That's the pink land.
That's the pink land. Pink land is in three parts. I think one can almost see three divisions on it.
That's the Harvey Vale estate.
Well,
part of it is.
It's to the south of the disputed land in any event, and it includes areas demised and areas licensed by the Crown, and includes land which is clearly seabed and foreshore on any view of the matter, and the Crown has demised that to CDC without any complaint from anyone, as far as I'm aware. So that's the first point. The second point, my lady, is this, that it is right, and I take squarely on the chin, the fact that the Crown claims and has always claimed ownership of coastal waters and the seabed up to the mean high level watermark. That is so in this country and in common law countries as well. And it's an important presumption. So the Crown is presumed in relation to land on the landward side of that to have conveyed it, so there's no presumption in its favour. But in relation to land on the seaward side of the high level watermark, it's presumed to retain ownership of that. And that's of equal importance, not just in places like Grenada and other Caribbean countries, but in this country as well.
Oh, we understand that. Mr. McGee, I think we'd better rise now in order to consider where we are.
Oh, yes.
Mr. we will hear the remainder of your submissions without prejudice to the question of whether there are concurrent findings of fact on both issues that we've raised with you, so as to invoke the principle in Devian Roy.
Lord, I'm very grateful. Can I...
of course, we've eaten into your time, but you have covered a great deal of ground already.
Well, that's one of the points I was thinking. I was saying to my learned junior, what else have I got to say? And one of the things I think it might be useful for me to do for your Lordship's benefit is to have a quick canter through the relevant conveyances and plans. If
just before you do,
yes.
I'm on page 728 of your invitation, the sketch plan that's attached to your case.
Yes, indeed.
Can you just help me? The disputed land is the 7 acres.
Yes.
What's that curious sort of dogleg that goes in from...
Above it.
Sorry?
Above the disputed land.
Well, it isn't actually the disputed land, is it? It's just above it.
Yes.
It goes into a sort of dogleg the other side of the public road.
So that was the subject of a conveyance from Mr. Roosevelt Corion, grandson of Samuel Corion. From Samuel Corion's estate in 1985 to Roosevelt Corion, one of his grandchildren, I think, of the whole of that dogleg.
Okay.
That's 1985.
That's 1985. And then, I'll come to this, but he then disposed of it in two parts. He disposed of the eastern part to the east of what's
the road.
Public Road to Mr. Lendor in 1990.
Right.
And then the western part, which is the bit hatched green, to Mr. Alexis in 1995.
Right.
So, and Your Lordship, just while we're on that plan, so Your Lordship see the disputed land hatched blue. Just to the right of it, there's a thin sliver in green. That's Mr. Lendor's other land. Mm-hmm. And then we've already noted that to the south of it, the pink land is the land subject of the lease to CDC in 2005.
Yeah.
And I suppose the other point that we can get while we're on it is there's a road coloured orange, and that road we will see on the Harvey Vale 1904 plan, and you'll see that it stops just before the boundary between the disputed land and the pink land.
Yes. And just one other question. There's a sort of wiggly line that starts at the root of the Harvey Vale jetty and goes northwards across the pink land where it's been largely obscured.
Yes.
And then picks up again running along the western edge of the disputed land.
Yes.
Across the next little bit, and then it continues on with a yellow edging inside of it.
Yes.
All the way up to what you might call almost the top left-hand corner of the sketch. Where did that little line come
we see that on a couple of the plans,
right?
And we see on the western side of that it's marked C.
Yes.
Sometimes.
So somebody thought that's where the sea ended and the land began.
Well, it would certainly appear to be a physical feature.
Yeah.
Whether it's certainly not marked as the mean high water mark.
No, but it's only a tide range of about half a metre at the greatest here, isn't it? It's a tiny tide range.
Yes.
But I thought that the pink land to the west of that wiggly line would be reclaimed land.
Yes.
Yes.
Or marina.
Yes.
The marina.
Yes, so it's clear. It's
so
clear.
that I'd sort of assumed that the wiggly line that then goes up and forms the western boundary of the disputed land and that dogleg piece of land, that was the sea on the west of it.
It's certainly clearly the sea on the western side, and it's right if one's looking at the pink land, one's got the wiggly line, and then to the left of that there's a line with straight edges.
Yes.
Between the wiggly line and the line with the straight edges is the reclaimed land.
Yeah.
And then between the line with straight edges and the further western part of the pink land is where the jetties and the marina are set out.
Yeah.
We'll see that a bit more clearly when we look at the
Right.
2005
But
CDC
the
plan.
7 acres that's disputed lands there, that is all, you say, swampy land and all foreshore?
Yes, it's foreshore and or sea. It's a seabed and or foreshore. Can I go through, what I'd like to do, if I may, is to go through, in the time that I've got left, is to go through the various conveyances and plans in turn and making 1 or 2 points as I go along. And I start, and I'd say it may be handy to keep that sketch plan open in the hard copy documents and look at the others elsewhere. If I can start from the 1885 conveyance, which starts at page 513. But mercifully, we've got, my suggestion, a transcript of it that starts at 516.1, and the relevant part is 516.3, and it is 6 lines from the top of that page, which sets out the parcels clause. It's that plantation in Grand Carenage and Carriacou, containing 160 acres or thereabouts, and now known as the Grand Anse Estate. So what we get from that, and all we get from that, was that the Grand Anse Estate contained 160 acres or thereabouts in 1885. There was no plan. The respondent, in its case, says that it was agreed that the disputed land was part of the Grand Anse Estate in 1885. We did not agree that. There was no evidence of it. Then there's the 1904 plan, which is at page 517. Lords, my lady, I've got A3 hard copies of that plan, if it would be useful for you to see them, but if it's sufficient to see them on...
I think it would be.
Yes, please.
I might as well hand up both of them for you. I'm also handing up the 1980 plan, just in case it's easier to look at in hard copy. So it's the yellowish one that we're looking at the moment.
Thank you. Beautifully drawn.
And this is identical to page 517 in the electronic bundle.
Yeah.
Thank you. So this is the
1904 plan,
Yes,
Yeah.
thank you.
upon which Malone and Friend places significant reliance. To orientate oneself, at the top of it, going west-east, there is a road marked Public Road, and that is the orange road on the sketch plan. So we're looking at everything below that.
Yeah.
And so, again, in order to orientate ourselves, one looks at the westernmost point, and if one were to extend the public road, which it doesn't, but if we extend it westwards, and below that there's a grey area marked swamp, that area of swamp is part of the pink land.
Yes.
Yes.
And the point that Malone and Friend places much reliance on is that above that it says Grand Anse Estate, and the disputed land starts from the northern bit of the grey swamp and goes upwards from there.
Yeah.
And one notices a couple of points. Firstly, that the area of swamp extends above that because those swamp-like, tree-like things have been extended above that. A number of other things one noticed. Firstly, that the westernmost boundary of the swamp has been extended a little bit further up, but only a very little bit further up. And similarly, the road is extended a little bit further northwards, but only a very little bit. One sees the word Grandance Estate, est, there, and one sees it in two other places, right at the very top and also on the right as well. And the point of that is to indicate that the Grandance Estate is to the north of the Harvey Vale Estate. And one sees that the Harvey Vale Estate, in fact, has got a bit, extends a bit in a square beyond the public road. There's plots 1, 2, 3, 4, 5, and 6 that are there. Now, my friend, I think, places a lot of reliance on the fact that Grandance Estate on the left-hand side appears directly above the swamp, and therefore including the disputed land. The person making this map clearly would not have wanted Grandance Estate to cut across the diagonal line going from point A, your lordships have that, which is on the swamp, northeastern part of the swamp, and a diagonal line upwards. That diagonal line is not a physical feature, it's just there, a measurement. It gives, I think, an angle. I think it's giving an angle from north.
You mean that's the triangle at the right angle of which is the Henry Vale
I think it says
School?
56 degrees.
Yes,
44 minutes.
Yeah.
Which I think, and if you see where, if you look at the bottom left where north is a little bit off to the left. It looks to me to be more or less 50. I haven't got a protractor, I'm afraid.
Where?
It looks to be about that.
It looks as if the whole thing's been surveyed by a series of horizontal sets and angles.
Indeed.
Of conspicuous items, such as the peak of that mountain or that hill to the south.
Yes.
And then various
So the point I'm making is
points set up on
that Grandance Estate was put there. It could have been put within the triangle, but the person printing the map would not want to put it across the triangle.
Why not?
Why not?
Well, simply because it would have broken up the line. And I think...
You mean purely for visual point of view?
Yeah, from a visual point of view.
Yeah. In other words, it's not a reason to assume that he didn't think the Grandance Estate extended all the way up to the boundaries of the Harvey Vale School, for example.
No, but exactly. But neither is it a reason to assume. What this map was not doing was purporting to set out precisely the boundaries of the Grandance Estate.
Officer, what is the point you're making about it not going across the line? I just haven't followed what the significance of this is.
Lord, it's perhaps not a point of the most enormous significance.
All right.
All I'm saying is the fact that it appears where the disputed land is, it could just have easily have appeared further to right within the triangle.
But so what? What follows from that?
It was not put there in order to identify the western extent of the Grandance Estate.
But if the Grandance Estate had not extended to where those words had in fact been put, then presumably the surveyor would not have put them there. He would have put them closer to the Harvey Vale School.
Lady, it might have done, but can I go to the...
Just following up my lady's point, this plan, which is a huge lotting plan for the Harvey Vale Estate, is assiduous in telling the reader who owns or of what estate all the neighbouring land across the boundary belongs to. I mean, you can follow it right the way around, and it's only where there's seashore that it doesn't actually do so with great precision.
Yes.
Presumably because it was regarded as helpful to those who would be taking some interest in this great process of lotting, know who their neighbours were going to be and who they would have to deal with, for example, in establishing boundaries.
Well, Lord, broadly, yes, but the purpose of the plan is, if one looks on the right-hand side, it says in large type, it's a plan showing the boundaries of the Harvey Vale Estate.
Yeah.
That was the purpose of it, and that's the only bit of that's shown in any detail whatsoever. So we say that you can't derive from this what the boundary of the Grand Anse estate was in 1904. And anyone wanting to ascertain where the boundaries of the Grand Anse estate was in 1904, or more importantly in 1914, would not have looked at this plan. Malone and Friends says, well, look, it was surveyed by order of the Director of Surveys, and that under the Boundary Settlement Ordinance, it was to be regarded as binding and was lodged at court, and Section 82 of the Evidence Act says it's presumed to be accurate. We accept all that. But in relation to the Harvey Vale estate.
But it is evidence, isn't it, that the land north of the public road and north of the Grey Swamp was part of the Grand Anse estate?
Well, we say, Lord, that it was not evidence of that at all, because that simply wasn't its purpose, and that in putting that point,
but something's been included strictly out with the purpose for which a document is prepared doesn't mean it's not evidence, does it?
Well, look, we say it's of no evidential value. We take your Lordship's point that those buying lots might want to know who their neighbours were. But the disputed land is not a neighbouring plot to plot 1, it's a neighbouring plot to the swamp, to the south. So we say it's of no value whatsoever. And in any event, no one in 1914, under the 1914 conveyance, would have looked at this plan.
Well, why does that matter?
Well,
because it's nevertheless objective evidence as to what was the limit of the Harvey Vale estate and where it reached a boundary with the Grand Anse estate.
Well, Lord, because one, we say it's not of any sufficient evidential value whatsoever, but even if it were, it only shows, to put the case at its very highest, that immediately to the north of that area of swamp was Grand Anse estate. It doesn't show that the whole of the disputed land, which extends a lot further north than that, was part of the Grand Anse estate. And furthermore, it's only showing the position in 1904, whereas we're interested in the position 10 years later in 1914. And can I turn now to the...
What is supposed to have changed during those 10 years?
Well, we know that between 1885 and 1914, the area of the Grand Anse estate changed from being 160 acres or thereabouts to 106.5 acres or thereabouts. So it changed enormously. And there's no evidence that that change occurred before 1904, or wholly before 1904, rather than after 1904. So this plan gets one precisely nowhere.
Well, even if it was only 106 acres, unless somehow the estate has been chopped around in strata going north, it would include the whole of the swamp, wouldn't it? Which is, after all, only 7 acres.
Well, if in 1904 it were 160 acres, we don't know.
But supposing it was 106 acres in 1904,
yes.
then common sense would suggest, wouldn't it, that given that the land immediately adjacent to the boundary of the Harvey Vale estate was part of the Grand Anse estate, that the 106 acres would move northwards from that line and would include the 7 acres, which is part of which is the disputed land.
Well, Lord, I accept that if it was 106 acres in 1904 and therefore did not change between 1904...
It's either 160 or 106 or somewhere in between. So I was, as it were, putting the case at its highest from your point of view and assuming it was 106 in 1904. I put it to you again, on that assumption, common sense would suggest that the 7 acres comprising the disputed land was within the Grand Anse estate.
But Lord, we say that simply doesn't follow with respect. If there were 160 acres in 1904, then somehow 54 acres have been lost between 1904 and 1914.
Then you invite the speculation that maybe some part of that 54 acres was this 7 acres.
Yes.
But of all the parts of the Grand Anse estate least likely to have been the subject of a conveyance, it would be the swamp, wouldn't it?
Well, in my submission, one simply can't speculate. There are a number of all sorts of possibilities. We do know that the swamp to the south was owned by the Crown and has been let to CDC.
Well,
we don't know what happened in 1914.
well, that was the purpose of building a marina. I'm not sure people were building marinas in 1914.
But Lord, my submission, the burden is firmly on my learned friend to show that in 1914, the Grand Anse estate included the disputed land. We say that the 1904 plan really doesn't get anywhere. After all, the purpose of it is to determine the Harvey Vale estate. We know that...
to determine where the Crown land finishes and non-Crown land starts, isn't it?
Lady, I don't think it's anything to do with Crown land necessarily at all. There's no evidence of who owned the Harvey Vale estate. It was surveyed by order of the Director of Surveys.
I thought we were told it was.
I thought it was owned by the Crown.
I thought so too.
Well, we know that...
Well, isn't that what you've built the pink area?
Well, we know that in 2005, when there was a lease of the pink land by the Crown, that nobody disputed that.
Oh, so Crown may not have owned the pink land either.
Don't know. We don't know. So I simply don't know one way or the other whether the Harvey Vale estate in 1904 was owned by the Crown or not. There's not been any suggestion that was so.
Do we have the Boundaries Settlement Ordinance number 2 of 1892 before us?
My learned friend has produced a supplemental bundle of authorities. It's not, I'm afraid, in the electronic bundle, and that does include that, Lord.
Okay. It would be helpful to see it somewhere.
Yes. And he refers to section 21 of that, which says...
Where do we find that? It's not in the electronic bundle.
It's not, Lord.
So are there hard copies?
There are hard copies. It was emailed through by all as well.
Right.
This morning.
If you want to...
This morning. Right. Came in this morning, apparently. So, is it convenient for us to have copies now?
It's certainly most welcome to you.
Thank you very much.
Here we are. It's the Boundaries Settlement. Here we are, yes. Thank you. This is down.
Yeah.
Yeah, thank you.
So if you want to look at it, it's the last tab, I think, and it's section 21. And section 21(1) says, a surveyor appointed by the Director of Survey shall complete any survey made by him, lodge it with the Office of Director of Surveys. subsection 2 says it's also to be lodged in the office of the Registrar of the Supreme Court. And subsection 3 says that if not contested within a prescribed time, then it stands confirmed and shall be binding on all parties.
And then 22 gives an opportunity to aggrieved persons to object.
Yes.
So if you were a neighbour, I mean, you'd likely look at the plan to see whether the plan wrongly included some of your land in the Harvey Vale estate, wouldn't you?
Yes. But it's binding. We say that this goes nowhere. It's binding as what it purports to be. That is a plan of the Harvey Vale estate.
But if the Harvey Vale estate in fact covered the land that's where the words Grand Ants Estate are written, I would have thought that the owners of the Harvey Vale estate would have objected to that and said, no, our land covers all those little swampy trees.
Well, they may or they may not. We simply say this is speculation. The other point, of course, to be made here is that there's no physical feature delineating the area between the grey swamp and the area to the north of that. In other words, there's no physical feature delineating the boundary between the pink land and the disputed land. That's simply a measurement, and I think it's another angle.
Yes.
But it's a notional continuation of the public road.
Indeed.
There wouldn't be any difficulty in a surveyor.
No.
I'm not suggesting there's any problem.
I'm not suggesting there's any
arises.
difficulty.
No.
I'm simply making the point that there's not a physical feature on the ground. But there's a plan of the Harvey Vale estate, that and only that. Question of the land surrounding that was of little, if any, relevance at the time, especially in respect to the area to the north of the swamp, not to the area to the north of one of the plots. Well, the next document I'd like
Just before you leave, could it be said that this survey gives at least some indication of where the surveyor thought that the land began and the sea ended? In other words, the mean high water mark, namely along the line that starts at the bridge into the lagoon, and then trending north-west, and then almost north, and then up into, beyond the grey swamp, into another swamp.
Well,
This surveyor didn't, on the face of it, think the swamps were part of the foreshore.
Well,
He may be right, may be wrong, but that's the impression one gets from looking at the plan.
that may be right, may be wrong. A couple of points I make about that. Firstly, that the line of the mean high water mark, which could indeed have been marked, is not marked. And secondly, so far as the seabed and foreshore presumption is concerned, the question is not where was the mean high water mark in 1914. The question is, where's the mean high water mark now?
Oh, yes, and it may have changed.
Yes.
Yes.
Because
I wasn't so much looking at the precise line as the delineation of swamp
yes.
as being on the landward side of it.
Well, what it was clearly indicating was that the area to the west of the swamp was sea and nothing but sea.
Yes.
It was at least making that point.
There's a thick line. If you look below the lagoon, there's a thick line with thin parallel lines on either side of it. When you look north of the lagoon, there's only, I think, little faint parallel lines to the west of the thick line. Now, what do those faint parallel lines indicate? Does that indicate the foreshore, for example?
Well, lady, we don't know. It's a point, of course, at which the surveyors might well have been qualified to give evidence, but they didn't give evidence on that point.
All right. Well, Mr. McGee, if we're going to complete this exercise in your
Lord,
time, we're going to have
I'm
to...
very conscious of the time, and I don't think I need to go to all the conveyances, but I should, I think, go to the 1914 conveyances.
It's of assistance that you're taking us through.
Indeed I am.
And I'm grateful.
Could I go, please, to that? It's 518. And again, I'm pleased to say that we have got transcripts starting at 520.1. And this is a conveyance to Samuel Corion, and the relevant words start, parcels clause, at the bottom of 520.2, 3 lines from the bottom. All that plantation or estate, lot, piece or parcel of land called and known by the name of Grand Anse, containing 106 1/2 acres, English statute measure, be the same more or less. And in this case, if I may, I am going to trouble you with just looking at one point in the original document. I can ask you to go to 519. And the point goes to this: 106 1/2 acres was not a mistake, as the judge suggested it might be, for 160 acres. It was clearly intended. One looks at page 519, 1, 2, 3, 4, 5, 1, 2, 3, 4, 5, 6 lines from the bottom. It says containing 106 acres, and then just after 6 there's a little arrow, and above that one can see and 1/2, open brackets, figures 106 1/2, close brackets, acres. So they were intentionally being quite precise about this. So the explanation cannot be, well, 160 is round about 106 1/2, or that 106 1/2 is a mistake for 160. There was a significant change during that period. Maybe the change was because of some exceptional storm meant that the area of foreshore went further eastwards. We don't know. That's also speculation. But there was a very significant change. There is no reason to think that it occurred before 1904 rather than after 1904. And given that evidence, clear, uncontroverted evidence of significant change, there was, we say, no evidence that the 1914 conveyance, which also didn't have a plan to it, included the disputed land.
But then you could never show that any of the land was within the 106.5 acres, because you could say that about any of the 160 acres.
Unless...
So you couldn't, if there's a discrepancy, you can't show that you own any of them.
Well, it's right that on the basis that this conveyance didn't include a plan, it was a difficult exercise. But if there had been evidence that in the period in question, a particular area was known to be part of the Grand Anse estate, then one could establish by this conveyance that it was conveyed. But that wasn't the way the case was put by the estate. It said, look at the 1885 conveyance, look at the 1914 conveyance, and look at the 1904 plan, and then, extraordinarily, look at the 1980 plan and the 2005 plan. They all show it was part of the Grand Anse estate. And the answer to that is, that's not the question. The question is a question of construction. It's the same question as construing a contract or any other consensual document, where you look at the words used in light of the factual matrix at the time and ask yourself, what did the parties intend to convey?
But where a conveyance doesn't have a precise plan and an issue arises as to what was included within it, you don't sort of stare at the thing without the plan until you're blue in the face and try and construe it. But you may ask, is there extrinsic evidence to show what that word meant, or that phrase meant, at or as near as you can get to it at that time?
Lord, I entirely accept that.
And that's an evidential task.
It is. Lord, on that question, can I go? I was going to go to two authorities. In 8 minutes, can I go to one of them, which is Alley and Lane. It starts at 793. Can I apologise in advance for the fact that this is not the report? There is a report in the property and compensation reports 2007 1 P&CR 26. This is the transcript. If you go to 804, paragraph 36, so here, Court of Appeal say it's permissible, this is 3 lines from the end of 36, it's permissible to have regard to extraneous evidence, including evidence of subsequent conduct, subject always to that being of probative value in determining what the parties intended. This qualification is crucial, but when one speaks of probative value, it's important to be clear what needs to be proved. In this case, the issue concerns the line of a boundary was fixed not later than 1947. Evidence of physical features were existed from the 1970s of no relevance to that, unless there's some reason to think they were in existence in 1947, or there are replacements of or otherwise related physical features that were in existence in 1947, etc. So I entirely accept, as one would expect in accordance with the ordinary principles of contractual interpretation, that one can have regard to extraneous circumstances, and they can even, in this case, include subsequent conduct, only if it's of probative value.
Only what?
Only if it's of probative value.
Well, that's true of all evidence.
Indeed. Yes, I suppose. Yes.
If evidence isn't relevant to anything, then it's, generally speaking, to save everybody's time, not admissible.
Yes. So, what we say is there was no evidence that was put forward that was of any value here. The 1914 conveyance doesn't get one anywhere unless one knows what the Grand Aunt's estate was in 1914. The fact that it's the 1885 conveyance only makes that task all the more difficult, given it was substantially larger, the evidence is, in 1885. The 1904 plan gets one no further, because it was a plan of the Harvey Vale estate, and anything else that was said incidentally about the Grand Aunt's estate has got no probative worth. Then Malone and Friends relied on two later plans, and in the time available, I think I can refer to the two others he relies on. Page 521. Oh, this is one you've also got in hard copy. It's the big white A3 plan.
Yes, thank you.
This is the 1980 plan.
This is the
1980 plan.
1980.
Yes.
Sure.
And is it right this indicates 163 acres?
Yeah, this says 163 acres, yes. So, I mean, the short answer to this plan is we're now 66 years after the 1914 plan.
But what conveyances had there been of the Grand Aunt's estate between 1914 and this plan?
There was no evidence either way on that question, Lord.
What do you mean either way?
Well, no one put any evidence that of any conveyances of the estate.
So, if this was a plan in 1980, but why is it not evidence of what was conveyed in 1914?
Well,
because people believe this to be the Grand Aunt's estate in 1980.
Well, firstly, it was prepared on the instructions of Roosevelt Corion, Samuel Corion's grandson.
Right.
It was done by Mr. Thomas, who gave expert evidence, but he says he did it without a survey and on the basis simply of what he was told by Roosevelt Corion.
Yes, I see.
Who would not have been alive in 1914 or even in 1921 when Samuel Corion died. So we say it's simply of no worth whatsoever.
It's of worth in the sense, I mean, it's evidence of what was believed to be the Grand Aunt's estate in 1980.
In 1980.
In 1980. But you say you can't make any connection between that and 1914.
No, none at all. Yeah. Well, we also know that if they thought, given that it said 163 acres, it's not consistent with the 1914 conveyance. So if we're to assume that the boundaries haven't changed, then they've acquired an extra 54 acres in that period of time.
Takes you back to 1884.
Right.
Yeah.
1885, sorry.
Well, yeah, 163 is not far different from 160 in 1885. But one doesn't know that the 54, the 50 odd that were lost between 1885 and 1914 are the 50 odd that were brought back in from 1914 to 1980. So we say it simply gets one absolutely nowhere. The other one that's relied on, that again can't possibly be of any relevance, is the plan to the lease of the pink land. The lease starts at page 659. Or it doesn't. No, the plan to the lease, which is probably sufficient, is at 659, where you can see these are the three bits of pink land, including the wiggly line. What was happening was there was a lease of Lot A, the bit to the east of the wiggly line, and then Lot B was to be reclaimed and was to be the subject of a further lease, and then there was a license to be granted of Lot C. The area of the disputed land lies immediately to the north of Lot A.
Yes. Headed private lands.
Headed private lands.
Yeah.
The purpose of this...
Whereas you say it should have been headed foreshore, owned by the Crown.
Well, it could have been, yes.
Or should have been.
Yes. By indicating it was private lands, it was indicating that the purpose of this plan, this was the plan to the lease. So the purpose of it was to show what was being let under that lease, lots A, B and C.
But they've taken care to distinguish between the private lands and the estate of the late Rufus Lendor, which is slightly to the east of the private lands.
It identifies Crown lands at the bottom too, doesn't it?
Yes, there's a little area just at the bottom marked Crown lands. But this, again, in my submission, can have no conceivable relevance to the position in 1914. The question in relation to the 1914 conveyance is, what was the Grand Aunt's estate at the date of that conveyance? This doesn't help on that question.
We have a plan in 1904 which shows the generally part of the disputed land belonging to the Grand Aunt's estate.
Yes.
And we have a plan in 1980, is this right, which shows the disputed land as part of the Grand Aunt's estate.
Yes.
But you say it tells us nothing as to what the position was between those two dates.
No.
But a pure happenstance that they happen to show the same position.
Yes, because we know in 1914 we only had 106.5 acres. So the fact that they were 163 is not far off 160. It's neither here nor there.
So you have to say that none of this evidence is of any probative value?
No.
Because if it is, then it's a matter for the tribunals of fact.
Yes. We say it's of no probative value. The way the tribunal approached it was wholly wrong by saying that it was a question resolved by the expert evidence of the surveyors, and it was not. And then we say, even if we're wrong on all that, even if the 1914 conveyance did purport to convey the disputed land, that does not get the estate the declaration it seeks because of the application of the seabed and foreshore presumption, for which one would need to show a conveyance by the Crown or adverse possession. I wonder whether I can trespass on your Lordship's time for one more minute to show you the reference to that important point on the strength of that presumption. It's page 940. The case starts at 927. It's Fowley, Marine and Gafford.
Oh, yeah.
And the relevant, there's a very short passage at 940 in the judgment of Lord Justice Russell, starting between letters C and D on 940. He says this on the second point.
Wait a sec, 940?
940, my lady.
Yeah.
Does your ladyship have that? Yes. On the second point, which would not by itself avail the plaintiff against the Crown, I'm prepared to express the view that in making title to properties such as foreshore, which must have been originally in the Crown, it's necessary either to show a Crown grant to some subject or to show a possessory title acquired against the Crown. It does not suffice merely to show a good root of title 60 years old. So that's why the 1914 conveyance, even if I were wrong on that, is not enough to get my learned friend home. Lord, I'm conscious I've slightly trespassed over the allotted time.
I'm not sure. I mean, this is back to your foreshore line.
This is back to my foreshore. This is back to the foreshore line.
Yes.
This is what I'm saying. That there are two hurdles the learned friend faces. One, he needs to show the 1914 conveyance includes the disputed land, and secondly, he needs to show that the foreshore and seabed presumption doesn't apply. If I win on either point, I succeed, subject to the question of adverse possession, which would need to be remitted back to the judge. Those are my submissions.
Well, you've had a disrupted morning, one way or another, but we're very grateful.
Thank you, Lord.
2 o'clock.